Hello everyone, good morning. Am I audible? Am I clearly visible to everyone? Are the slides visible? Can someone tell me? Hello? Am I audible? Okay. Okay, thank you. Oh, hi Khushi. Good to see you again. Good afternoon, Bhavna. We'll be starting in a bit. Till then, we asked you a question. What are your guesses? What do you think these judgments are going to be? We took a live session last week. We discussed some judgments. Some of you were there. So tell me, what judgments are we going to cover today? Any one guess? Anybody? Also, Barbenheimer said that they want me to take the session in English. So, is it okay that I take the session in English, or do you want me to cover it in both Hindi and English? It's a democracy. You have your say as well. Tell me what the judgments are going to be. Anyone? Khushi, can you tell me? You were there in the last session. What do you think this time the judgments are going to be? If you can guess from this image, you can make a guess as well. POXO, close. Okay, so we start the session. So today we are going to cover some more judgments as asked by a lot of you, and I received some responses in the last mail as well. So good, keep that up. Today we are going to cover more such judgments, some very important judgments which are going to help you in your exam preparation for any entrance, master's entrance examination for law. So without wasting any time, let's POXO PESA. Let's look at the judgments. So the first one is Common Cause versus Union of India. So do you know when was this judgment delivered and why are we covering it today in the year 2023? Anybody, any idea? Common Cause versus Union of India is a very landmark case. What does it relate to? Article 21, yes. What is Article 21? Right to life and personal liberty. Good, Khushi. So, this judgment related to passive euthanasia. Now, what is passive euthanasia? I'd explain in the coming slides. So, for that, before starting, I want you to tell me, does the right to life under Article 21 include the right to die? Euthanasia, yes. Do you think Article 21 which states talk about right to life includes right to die as well? Do we have the right to die as per Article 21? With dignity, yes, good. Yes, yes, Anushka, correct. So this judgment was about euthanasia. Euthanasia is if a person is really sick, ill, and is in permanent vegetative state or in a state where there is no scope of improvement of their health. So there are two ways in which their death could be made peaceful. Now, what are the two ways? There are two types of euthanasia, and for that you need to, for this judgment in general, you need to know two terms. The terms are living will and advance directive, which the common cause judgment dealt with, and the other one is passive euthanasia. So euthanasia, like I told you, are of two kinds, active euthanasia and passive euthanasia. Now what is active euthanasia? A doctor or some health provider would deliberately use some injections or some medicines or some ways to help the people who are in permanent vegetative state. So for that, active euthanasia is used. Injections are used to basically let them die if there is no scope of recovery. Now what is passive euthanasia, which is very important for this case? Passive euthanasia is taking support system of their medical health. Now if they are living because of medicines, if they are living because of some kind of injections or medical support, so the doctors will decide to take that off, and that would count as passive euthanasia, that is not actively taking their life. So in this case, passive euthanasia was dealt. Now the common cause judgment stated that right to life includes right to die with dignity. But there was some, the process for that involved advance directives. So what are advance directives? It is basically, let's take my example. So I'm a person, I feel that at the age of 70, I might not be able to take a decision regarding my health. So in case that I feel terminally ill and I get very sick, so I'd write a document stating what I want if I get into that state. So that is called advance directive. Advance directive includes living will. So advance directive is a wider term, living will is a part of it. So in these directives, there are multiple steps involved to get these directives. Not everybody could take it. There is a procedure which is very technical. So that is why the Supreme Court delivered some judgments. There have been multiple judgments on right to die. We'd be covering that as well. So living will or advance directive is the term you should remember. Now coming to the right to die, we quickly run through these judgments. If any one of you can tell me any of these judgments, what are these about? Aruna Shaunbag or Gyankor versus State of Punjab, these included right to die. Does anybody know P. Ratinam versus Union of India? What was the case dealt with? All of these cases deal with, in a way, right to life and right to die. We quickly cover it up. I'll give you 1 or 2 minutes. Active euthanasia. It said that right to life includes right to die. Passive euthanasia, okay. You guys, you all are somewhere correct. So P. Ratinam versus Union of India dealt with section 309. Section 309 deals with section 309 of IPC, Indian Penal Code. What it deals with? It deals with attempt to suicide, which is a crime in India. It's an offence. So in this case, it was held that attempt to suicide, making it a crime, is against the right to life. So right to life includes right to die, was held in this case. So what happened then? In this case, this P. Ratinam judgment was reversed, and in this case it was held that right to life does not include right to die, because attempt to suicide is deliberately killing yourself, so that cannot settle into the fundamental rights of provided under the Constitution of India under Article 21. So in Gyankor it was held that right to life does not include right to die. Again, in Aruna Shaunbag versus Union of India, it's a very known case. The facts of the case, you might all know the facts of the case. So in this case, the Supreme Court, while dismissing the petition, held that if the hospital who was taking care of Aruna Shaunbag wanted to use passive euthanasia at a later stage, they are allowed to do so, but they have to approach the High Court and under Article 226 and take permission of the High Court before using passive euthanasia. So for the first time, passive euthanasia was dealt in Aruna Shaunbag. Now coming to the landmark case of Common Cause versus Union of India, we just discussed, it dealt with right to life includes right to die with dignity. That is an important part. So in this judgment, advance directives and the guidelines for that were set. So these guidelines were basically very stringent, very lengthy, and involved a lot of process. So to make it easy, in 2023 an application was filed, and as a result these guidelines were amended or revised to make it more easy, simpler. So if you want to, you can take a screenshot of this. These were the 2018 guidelines, these are the 23 guidelines changed. So in 2018, what was the role of JMFC? So these advanced directives if I am the person who's issuing these advance directives, I'd be called the executor. So the executor would sign this document, the advance directive or the living will, whatever the document is, and they'd have to do it in front of 2 witnesses, preferably independent, and then it should have been countersigned by JMFC. What is the full form of JMFC, if anybody can tell? What is JMFC? Khushi, Anushka, anyone? What is the full form of JMFC? It's a common general knowledge question. Yes. Good, yes. It's Judicial Magistrate First Class. Yes. So, countersigned by JMFC was the previous guideline. It had to be countersigned by JMFC. The new guidelines, in the new guidelines, this was changed to make it easy. It had to be in front of 2 independent witnesses or 2 witnesses, but it did not have to go to JMFC. It could just be dealt with a gazetted officer or a notary. So, that was made easy. Now, regarding information, in the previous guideline, the JMFC had the duty to inform the family members or the family doctor, if any. But in this new guideline, the responsibility of informing the family was not with the JMFC, it was given to the executor. That is, if I am the executor of my living will, I am responsible for informing my family. So this was held in the new guideline, revised in the new guideline. In the previous guideline, medical board was constituted. So in that medical board, 3 experts with at least 20 years of experience was necessary. So this made the procedure more difficult. What were the new guidelines? 2 experts with 5 years of experience. So it was reduced very much in this new guideline. And also in medical board, there were 2 boards that were to be constituted. First, the primary board was to be constituted by the hospital. The second board was constituted by the collector of that city or the district, whatever that is. So the collector had the responsibility to form the secondary board. Again, this is a cumbersome process. So to reduce that, in the revised guidelines, only the hospital had the responsibility to find the primary board and the secondary board. Now, coming to these were the major guidelines. It has been discussed in detail in the cases, judgments we have covered in the course. You can refer to that to see what are the guidelines. There are more guidelines than that. These were the major guidelines. A quick question, quickly, we revise what we just learned through this. Good morning, good day, Rishi. So, come on, quickly. Let's match the following. 1C, CAB. Okay. 1C, 2B, 3A. 1C, 2B, 3A. Okay. This is not the right answer. What's 3B, 1C, 2A? Khushi is saying 3B, 1C, 2A. 3B, 1C, 2A. Okay, so this is the right answer. Section 309 deals with attempt to suicide, we just discussed. Aruna Shaunbag judgment was delivered in 2011. In Common Cause versus Union of India, dealt with right to life, includes right to die with dignity. I hope that is a quick way to learn how these judgments, you'd remember the same? Okay, Yash, apologies, yours was the same. Moving on, we deal with Kaushal Kishore versus State of Uttar Pradesh. Now, this judgment dealt with freedom of speech and expression, but there's a twist. It did not just deal with freedom of speech and expression of everybody, it dealt with freedom of speech and expression of public official. Now, a public official is a person who's responsible for the state. He is representing the whole country, he is elected by the people. So, in this case, I would start with a question. Now, let's assume that I am a public official and I make a statement, taking the facts of the case. In this case, there was a politician and he made a statement regarding 2 rape victims. And if I am a public official, can I make any statement regarding some sensitive matter and just, could it be left aside, leave aside? Is that possible? Do you think Do you think that if I am a public official, I have a duty or a responsibility to be more serious with what I am saying? Or do I have a free? No, there is no duty. I have no duty, is what you're saying. I can say anything and everything like every other person. So in this case, the facts of this case, let's understand this with the facts of the case. In this case, a politician named Azam Khan made a statement against two rape victims. What were so these two victims of rape went to the police against their to file an FIR for the crime that was committed to them. So Azam Khan said that this is a political propaganda or an agenda to defame or to incite something against the government, the then government there. So was this statement will be contributed to the government, or was it declared in the individual capacity? Is that allowed? No, I mean there are restrictions. Yes, there are restrictions. No, ma'am. Yes, there are reasonable restrictions which are applicable to everyone. So in this case, the main contention was, what does Article 19(1)(a) states? It states it deals with freedom of speech and expression of everyone. So under Article 19(2), there are reasonable restrictions to it. Can somebody quickly tell me the reasonable restrictions there are? There are certain one or two, anything that comes to the top of your mind, that these are the reasonable restrictions that are applicable under Article 19(2) of the Constitution of India. Public order, yes Khushi, great. Good. Morality, nice. Should not be against morality or society. So yes, you guys are correct. Basically 19(2) deals with a number of restrictions. So in this case, the Supreme Court held that even public officials are governed with this law, and no additional restrictions other than one mentioned in Article 19(2) can be imposed on public officials as well. They don't have any separate responsibility towards their speech. So the restrictions mentioned under Article 19(2) are enough to cover everything. So the court held that these any restrictions beyond the ones mentioned in 19(2) will be held unconstitutional. Now the second issue was, can citizens claim right to life and liberty violations against non-state actors? So non-state actors are basically private people. So can anybody claim their right to life and personal liberty under Article 20 against non-state officials? So the Supreme Court held that yes, they can claim the right to life and personal liberty against non-state official as well. But here's one thing is important to remember. Justice Nagratna gave a separate opinion. What did she say? That yes, people can go against non-state actors as well, but not directly under the Constitution of India. If there is another remedy available, so they should first approach that remedy. For instance, if there is an assault against them, so it is a right of their Article 21. So they should go first before the Indian Penal Code, under the Indian Penal Code, before going under the right to life and personal liberty of the Constitution. So Justice Nagratna gave a different opinion. Coming to the next issue, is the state obligated to protect citizens? So yes, it's a very generic question. State is obligated to protect everybody under Article 21 of the Constitution. So the court held that the state should make sure that a person's liberty is not violated or by a non-state actor. And should the statements made by public officials be attributed to the government? So let's say I'm a person who belongs to BJP or a Congress party, and I make a statement. So will that be attributed to the party itself, or it's my responsibility, my problem? What do you think? Do you think if I make a statement, I am a person belonging to a political party, so that statement should be attributed to the political party I belong to? It's a yes or no question. Yes, it should be attributed to the political party. No, it is stated in an individual capacity. Personal responsibility. So yes, the court held that statements made by a minister outside the houses, so if it's not regarding the policies or the functioning of the government, it is stated outside the office, outside the houses, and in personal capacity, so it cannot be attributed to the personal. So in this again, Justice Nagratna gave a separate opinion. She held that the public officials are not responsible for, the political parties are not responsible for their party leaders or anybody for their statements, but if they go to the strength or stretch of hate speech, then they should be held liable. So they should not make any and every statement. If they make any statement which is against the Constitution of India or includes hate speech or something which can incite violence or against the morality and grounds mentioned under Article 19(2), then they should be held responsible, and the party should be held responsible for their statements as well. Good. Nice. So the last issue was, is the government liable for the statement made official in so constitutional right violation was the main concern here. So is the party liable? So in this, if there is a constitutional right violation, so in this regard the court held that if that hate speech or that statement made by the political leader incites some kind of result or anybody takes action because of that speech, then yes, it would be counted as constitutional right violations, otherwise it won't be. So only if it violates a constitutional right and not otherwise, it will be counted as a constitutional right violation. Now a simple question, very simple one. Is the internet shutdown an additional restriction in to freedom of speech and expression? After this, we are going to discuss a very important judgment according to me of this year so far. So let's quickly answer this. Is internet shutdown? We know recently the Manipur violence and the Haryana violence has resulted in internet shutdown in these areas. So is the internet shutdown an additional restriction to freedom of speech and expression? It's a personal opinion question. Okay, so according to all of you, it is an additional restriction to freedom of speech and expression. Because does it violate? No. Okay, Rashmi is saying no. Okay, Barbenheimer is saying no as well. Okay. So internet shutdown is not against freedom of speech and expression. It is a reasonable violation. It should not be stretched so long that it's affecting the right to life and personal liberty or freedom of speech and expression of a person. So it is a reasonable restriction, but it should be taken reasonably. Coming to the important judgment, according to me, is, what do you think it is? What do you think this judgment is about? 2023 judgment. I think it was the first judgment of 2023. And in a way, it was a retrospective judgment. It was declared for a judge. Oh, good, yes. Yes, demonetization. Ban of 2000 notes. Close. Because, okay, 2000 note is here. But demonetization judgment. So we all know in 2016, the government suddenly woke up and decided ki no, we cannot circulate 500 and 1000 notes anymore. We will just be circulating the rest of the notes. So in 2006, demonetization happened and the judgment was delivered in 2023. So let's understand this case. There's a timeline now. Was this the first time a demonetization happened? No. In 1946, 1000 and 10,000 banknotes were demonetized. In 1978, 1000 and 5000 and 10,000 banknotes were demonetized. Then in 2000, sorry, this should be 2016. In 2016, rupees 500 and 1000 banknotes were demonetized. So these were the 3 times it was demonetized. Quickly, one short question. Does any one of you know what was the time period given in this demonetization? What was the time period given to take the money back? People were allowed to deposit their money. So in this case, around 52 days or 54 days, more than 50 days were given to the people to return their notes or to submit to the bank whatever they had, the bank notes. In this time, in 1978, there was a very short period of time given and which was discussed in the case, demonetization case. Anybody has any idea? It was a very short span of time given. Make a guess. Anything. Very short, like 1 week. Close. Yes. Khushi is almost right. 8 days. 8 days were provided to return the amount. So in this case, also in the demonetization case, it was held that the amount of time which was given was enough. That was one of the major grounds. That is why you need to remember this thing, because the judges held that previously only 8 days were provided. So giving 52 days is more than enough. So in this case, remembering section 26 of the RBI Act is important. What does section 26 of the RBI Act deals with? It basically states that if the government wants to demonetize it, any currency or any banknote, the RBI has to initiate the proceedings. It should be initiated on the recommendation of the Reserve Bank of India. So what happened in this case? The main issue was the move to demonetize done according to the RBI Act. So the Supreme Court held that yes, of course, it was done according to section 26 of the Act, because it was done on the recommendation of the RBI. In this case, the bench of the Supreme Court decided that the word recommendation would include consultancy. So this was a new, different approach the bench take by applying purposive legislation. Now in this, the Supreme Court held that, like I said, section 26 of the RBI Act was taken into consideration, and consulting the RBI, the step was taken. So the government can demonetize any currency note. So in section 26, one word is used, any. So that any word was interpreted in this judgment, and it was held that this any word would be called as all in this case specifically. So it would differ in cases to cases. So any would include all. This you can remember. Another issue was the demonetization scheme implemented in an unreasonable manner? So again, the majority judgment held that the scheme was not implemented in an unreasonable manner. So why did I say majority judgment? Because again, in this case, Justice Nagratna gave a dissenting opinion. You need to remember that. Who gave the dissenting opinion in this judgment? Justice Nagratna. So Justice Nagratna gave a dissenting opinion in this, and she held that the process was not done according to the provisions of the Act, because RBI did not recommend the process. It should have been done through a legislation or a notification, and just announcing it and stating it as on consultancy with the RBI does not amount to proper procedure. Now, coming to the next issue, what is the scope of SC's power to review economic policy matters? This is an important issue from constitutional point of view. So, do you think can constitution or the judges have the power or the capacity to deal with economic matters? Do you think judges? Yes, 4:1 majority, good. Justice Nagratna gave the dissenting opinion. You can refer to, we are quickly going through the cases here. We have covered all of this in very detail in our judgment section of the course. You can refer to that. We have also done the case analysis. So, can Supreme Court interfere in economic matters? Do you think Supreme Court has that much of a wider power? There have been multiple judgments regarding that. You might find the answers here as well if you could peek. There is an answer here somewhere. Anybody? Khushi? Can you tell me the answer? No. Barbenheimer is saying no. Khushi? Jyoti? Anybody? Sushant? Okay. I think you need answers from me. Yes, Yash is saying yes. So the government has power to interfere in economic matters, but only in rare cases. If there is in some way constitution involved, matter of law involved typically, then only the Supreme Court can interfere in economic matters. Otherwise, it is better left to the experts, better left to the people who know the economies or the procedure well. So the Supreme Court held that it is a settled law It is a settled law, meaning in various judgments the Supreme Court has held that economic policies are best left to the expert possessing the required knowledge of the economies. So this is an important judgment. You should refer it in detail as well. Now, was the move to demonetize the 500 banknotes a right move or a wrong move? What do you think? Right or wrong? Although this move has already been taken, there is no going back, you cannot do anything. But according to you, was it a right move or a wrong move? And similarly, there is going to be a judgment on Article 370 as well. Now we know the abrogation of it took place a while back, and now the judgment is being delivered. Do you think that the Supreme Court delivering judgments way after some steps have been taken is fruitful or not? You can take this as a homework. You can go and research and do your homework as well. So it was a right move according to Sushant and Yash. Okay. Now coming to the next case, Orellano Fernandez versus State of Goa. Now this case dealt with POSH guidelines. What are POSH guidelines? It deals with prevention of sexual harassment at workplace. So let's take an example. I am a student or a teacher and I face sexual harassment at the end of a professor, a fellow student. What is the mechanism? Where do I go? Where do I go with my complaints? Is there a mechanism? Is there a body which deals with this? Is there an act which deals with it, which provides me relief or redressal if I am facing sexual harassment at workplace? Vishakha guidelines. Good. Vishakha guidelines were there, but it has been replaced with a proper act now. Anybody knows the answer to that? POSH Act. The name is, in short, Prevention of Sexual Harassment at Workplace, but the act is different. It is Sexual Harassment at Workplace Prevention, Protection and Redressal Act. It came out in 2013. So it came out way back, but the Supreme Court in this case found that it is not implemented properly. So it issued certain guidelines. What were these guidelines? It was to verify as to whether all concerned authorities have ICs or LCs. Not what are ICs and LCs. These are internal committees and local committees where a person can approach. So the Sexual Harassment at Workplace Act provides mandatorily that there needs to be internal committees and local committees at every organization and district level, so that if anybody is facing any sexual harassment at workplace, they can approach these committees. So people are not informed. Generally, I don't know whether you are informed about it or not, but there are committees in workplace as well to basically redress this issue. The second guideline was information regarding POSH to be available on the website of all organizations. Because of lack of awareness, people don't approach the right authorities, or people just keep it to themselves if they're facing any sexual harassment. So the court held that every organization's website had to have a separate guideline regarding POSH on their displaying on their website. Similarly, the court issued that it would apply to professional bodies like lawyers, chartered accountants, educational institutions and all professional bodies, similarly doctors. So it would be applicable to everyone irrespective of whether it's a government organization, private organization, schools, any kind of institution. Further, the court held that familiarize members. So sometimes even the members of the committees don't know the procedure themselves. So for that, the court held that the members of the committees had to familiarize themselves with the procedure that has to be followed according to the act. Also, orientation programs, workshops. So the main problem that could be summarized here was that lack of awareness. So for that, these guidelines were issued by the Supreme Court in Orellano Fernandez versus State of Goa. Remember that. So if any question comes from this case, it could be regarding POSH Act, it could be regarding Sexual Harassment in Workplace Act, it could be regarding what are the provisions. If people do not go to the POSH Act, then is there any provision under IPC, whatever other laws there are. So questions regarding that could come up. Now, we have a question. I told you some basics about the act. Do you think I have a colleague who's a male or who's a transgender, or they are not a female basically? So do you think they can go under the POSH Act and apply, file a complaint if they face any sexual harassment according to the POSH Act? No. Yash is saying no. Yash is saying no. Anybody else? Do you have a separate opinion? Can males file a complaint? Can other genders other than females can file a complaint? Sushant, Anushka? No? I think we'd go with Yash. Yash ka answer. Under the POSH Act, males or transgenders or other genders cannot file a complaint. There is an alternative. Companies can make their own guidelines, a separate guidelines under which they can include every gender to file a complaint, but under this act there is no mechanism for males to file a complaint. Now the second question, does the transportation vehicle, so let's assume I'm in a bus and I'm basically facing any kind of uncomfortable sexual behavior from someone else. So I am just in a bus, I haven't faced it in my office. So will that be included as sexual harassment at workplace under the POSH Act? Can someone tell me? Yash, Sushant, anyone? Do you think transportation vehicle comes under the definition of workplace according to the POSH Act, according to the Sexual Harassment at Workplace Act? At the end of this video, we'd be giving out something free, something which you could use for your exam preparation, something which is available for everyone. So make sure you're staying till that. Until then, answer this question. IPC 354 if not POSH. ठीक है. Tell me about an answer to this question. No, because it is usually treated as not in the course of employment. So I would correct you, transportation vehicle is included as workplace according to the POSH Act, and if someone is facing sexual harassment in a work related person, from a work related person, it would be constituted and considered under the POSH Act. So this answer is yes. It is, transportation vehicle is counts as a workplace under the POSH Act. Coming to the third and last question, can you file a fake complaint of sexual harassment at workplace? It's a generic question, very simple, you should know. Do you think I can file a fake complaint and just, it would be just set aside, okay, mistakes happen, it's okay. She filed a fake complaint, it's alright. Do you think that could happen? No. Yes, maybe. Of course, I can file a complaint. Then investigation would happen from the internal committee, and if the committee realizes that it's a fake complaint, so they can punish me for filing a fake complaint. So it's not advisable to file a fake complaint, because if they find out in the later proceedings of the case, I would be charged against it. It's not like I'd be set aside, or it's like it would be considered as a genuine mistake. I'd be punished for it. So filing a fake complaint of sexual harassment under the POSH Act invites an offence. So don't do that. Now coming to the last question, last case. After that, we'd be distributing that free whatever we have discussed. Have you? So, but she'll be held liable. Yes, good Sakshi. So this case is X versus State of Maharashtra. Now it's a very sensitive case. Again, I would start with the facts of the case and ask you people to tell me what should happen ideally. So I'm a person, let's assume I'm a person who has faced sexual harassment at the hands of a person, casting couch case. This was a casting couch case. So I faced sexual harassment, I gave complaint, the police filed an FIR. In the after the FIR, because of the provisions that were framed in the FIR, the person who was accused of the sexual harassment was given bail. Now further, after making more statements, it was realized that not only sexual harassment but rape was committed as well, and that means it became a non-bailable offence. So what do you think? If initially it is found that a crime has been committed in which you can ask for bail, but then later on you realize that it's a non-bailable offence. So can the court cancel a bail based on that additional charges? What do you think? If I have already got a bail on a case and additionally more charges are applied to my case, so can I receive a bail, or will that bail be rejected because of those additional crimes? Court can cancel bail, yes. Okay, nice, good. Everybody is active now. Great. So this is the last case and everybody is here now. Wow. So yes, it is true. In this case, it was held that if in the later stage of the proceedings, if it is found that a person has committed more grievous offence, which is a non-bailable offence, the court has the power to cancel the bail and to basically take that person under that offence as well. So, like I said, can the court reject the granted bail, which has already been granted, if a non-bailable offence is added through a supplementary statement in the FIR? So, the court held that addition of a serious offence can be a circumstance. Again, it was a very serious offence. So, adding a serious offence to a circumstance can direct that the accused be arrested and committed to the custody even though an order of bail was earlier granted. So, this was held in this case. Now, again in this case, anticipatory bail was taken by the accused. So, what is the provision of anticipatory bail under the Code of Criminal Procedure? Last question, last part of the case, last part of the live. Quickly tell me, search it up on Google if you want, quickly tell me under which provision of the Code of Criminal Procedure can I apply for anticipatory bail? Sakshi, no, that's a wrong answer. Yash, right, okay. Khushi, yes, it's a pre-arrest bail. Anticipatory bail, yes, he is right. Anticipatory bail is basically, I am thinking that I might get arrested at a later stage. So, I would go for asking for a bail even before there is an announcement of me going to jail. So, anticipatory bail is pre-arrest bail. Yash is right. The correct answer is, hi Krish, the correct answer is, now Sakshi, Yash, everybody is correct almost. Mayank, the correct answer is section 438. Under section 438 of CRPC, anticipatory bail, apprehension of bail in non-bailable offence. Good Sakshi, great. So, under section 438 of the Code of Criminal Procedure, anticipatory bail can be taken. This was all. Do you have any questions, any doubts? Section 438 is the answer. You should mail us whatever doubts you have. If you have any suggestions, what do you want us to take the live session on? Like I told you, it's a democratic process. Tell us what you want us to take live session on. We take it into consideration, and whatever the majority says, we take the live session on that topic, on that judgment, whatever it is that you want. Do you have any suggestions? What should be the next live session should be on? The first part is available in the course. We'll be uploading it soon if it's not uploaded. It will be available on the course. You can watch it there. Succession and inheritance under Hindu personal laws, okay. Case studies, okay. In-depth case studies, is that what you're asking, Shruti? Should we pick up one case and discuss it in detail, or do you want something like this, similar to this? इंटरव्यू बेस्ड क्वेश्चंस करा दीजिए, ठीक है. We'd be covering judgments regularly, that's a given. This was part 2 of the judgment. We've already covered part 1. As and when important judgments come, we'd be covering that in further live sessions. We'd also be dealing with the non-constitutional topics. These were majorly constitutional topics mostly. So we'd also be dealing with cases, topics like arbitration and criminal procedure code, IPC, criminal offences, everything. Thank you, Yash. Thanks. You should be there in the next session. In-depth also sometimes. We do take in-depth sessions as well. We've previously taken full case studies, live sessions as well. You can check it out. I hope you're regularly checking out the courses and the mails we're updating you with. Latest legal updates, yes. Yes, Jyoti, the answer is 438. I think this is all for today. Thank you all for joining. I hope you have received your freebie or not. If you should be receiving it soon, check it out. We have circulated the PDF in which we have covered this in detail, the whole live session. If any part has been missed by us, it is covered in that PDF. Make sure to check it out. Read it if you want. There are some interesting questions at the end of that as well. Thank you, Sushant. Thank you so much. Check that PDF out which we've recently circulated and let us know what more you need. Mail us. You know our mail IDs. You know where to contact us. Text us on Instagram or Facebook, wherever you're comfortable, or WhatsApp. Thank you.